Ever feel like you're caught in a legal maze?
Mm,
Today we're diving deep into those tricky spots where state and federal laws collide. You know those moments where it's like two different rule books are battling it out?
yeah,
We'll unpack some pivotal court cases and concepts.
right.
And don't worry, we'll make sure you don't need a law degree to follow along.
It's definitely an area of law that can get really complex really quickly.
Yeah.
But understanding these clashes helps us see the checks and balances within our legal system in action.
Okay, cool. So our journey begins with seemingly simple idea
Yep.
found in 28 USC 1652.
Okay.
Basically, it says federal courts should apply state laws,
Mm-hmm.
unless federal law specifically says otherwise.
Right.
Sounds straightforward enough, right?
Yeah, it does.
But I have a feeling there's more to this story.
Oh, you are so right. It gets much more complicated.
Mhm.
This seemingly simple concept actually caused decades of confusion and some serious head-scratching in the legal world.
That's where our first stop takes us. The case of Swift v. Tyson. Back in 1842.
Oh, yes, Sophie Tyson.
It revolved around whether a pre-existing debt was valid consideration
Okay.
for a bill of exchange.
Right.
I'm already a bit lost, to be honest.
Okay.
What exactly was the issue there?
So under New York law at the time, using a pre-existing debt to essentially back up a new promise to pay wasn't considered sufficient consideration.
Okay.
To make that new promise legally binding, think of it like trying to buy something new
Okay.
by saying, I'll pay you with the money I already owe you. Not quite the same as a new exchange of value.
I think I'm starting to get it.
Okay.
So New York had specific rules about what counted as a valid debt for these types of financial transactions.
Exactly.
But federal courts didn't necessarily follow those same state-specific rules.
Exactly. Back then, the Supreme Court was trying to create a more uniform federal common law.
Uh-huh.
So they essentially gave federal courts leeway to apply their own interpretations, even in matters involving what we might consider state-level commercial law.
Ah. So that's where the trouble began.
Right.
This attempt at creating a unified system actually backfired,
It did.
creating inconsistencies and confusion. Kind of like trying to have a standardized national exam.
Okay.
But each state gets to decide on the curriculum and grading scale.
That's a great analogy.
Yeah.
And just like with those exams, the results were predictable. A whole lot of inconsistency.
Yeah.
Different federal courts were applying different standards,
Right.
which definitely threw a wrench into the idea of legal predictability.
It almost sounds like it created an opportunity for people to play the system a bit.
Yeah.
If they thought a federal court would be more sympathetic to their case, they might try to get it heard there instead of state court.
You're exactly right. That's what we call forum shopping.
Right.
And it became a major issue after Swift. One of our sources actually highlights the black and white taxi cab case from 1928 as a prime example of this.
Right.
The company literally reincorporated in a different state
Yeah.
just to get their case heard in federal court.
Wow. Talk about going the extra mile to get a favorable outcome. So we have confusion, inconsistency,
It's a mess.
and strategic maneuvering to avoid state laws. Sounds like a recipe for legal chaos.
Yeah.
That brings us, of course, to the case that overturned Swift
Yet.
and tried to bring some order back to this whole system, Erie Railroad Covey Tompkins.
Erie is definitely a landmark decision in American law. It completely reshaped the relationship between state and federal courts when dealing with issues that fell under state law.
And it all stemmed from an incident where a man was injured
Right.
while walking along a railroad track in Pennsylvania. The question was whether he should be considered a trespasser,
Okay.
which would affect his ability to sue under Pennsylvania law.
Right.
The lower courts, still operating under that Swift doctrine, decided to apply federal common law, which would have been more favorable to the injured man. But the Supreme Court saw this as a major overreach of federal power.
They did.
And this is where things get really interesting, right? The court didn't just overturn Swift. They declared it unconstitutional
Wow.
after it had been the law of the land for nearly a century.
Yeah, almost 100 years.
Yeah.
Wow.
The court essentially recognized that federal courts, especially in cases involving citizens from different states, shouldn't be in the business of creating their own versions of state law.
Right.
This was especially true for areas of law that had traditionally been left to the states to decide,
Right.
like personal injury law in this case.
Makes sense.
So the big takeaway from Erie is that in diversity cases, which I'm guessing means cases where the parties are from different states,
Yes.
state law, even state common law, should be the guiding principle.
Right.
It makes sense that a federal federal court sitting in Pennsylvania
Right.
should apply Pennsylvania law
Yeah.
if the lawsuit arose in Pennsylvania.
Exactly. It's all about respecting the sovereignty of states to govern their own affairs
Right.
and ensuring that someone's legal rights don't change just because their case happens to be in federal court.
Uri was a course correction.
It was.
But, as we'll see, it also raised a whole new set of questions.
Of course it did.
For example, what happens when a case involves multiple states?
Yes.
Which state's law wins out then?
That's where things start to get really interesting. The quest for clarity and fairness in these state versus federal clashes continues, and our next stop will take us deeper into those fascinating complexities. You're right to point out that while Erie was a landmark decision, it didn't magically solve all the issues surrounding conflicts between state and federal law. Cases involving parties from multiple states are a great example of that.
Right. We ended part 1 with that very question.
Yes.
If a case crosses state lines, how do courts determine which state's law applies?
Right.
It's like trying to assemble a legal puzzle where the pieces are scattered across different states.
A very apt analogy. And that's where a case called Claxon v. Stenter comes in,
Okay.
adding another layer to this legal puzzle we're putting together.
Okay.
It tackled this very issue of which state's law applies in these multi-state disputes.
So did Claxon give us like a clear formula
Well,
for picking the winning state law?
not a formula exactly,
Okay.
but Claxon established a rule that adds a fascinating twist.
Okay.
It determined that federal courts should actually look to the conflict of law rules
Okay.
of the state where the federal court is located.
Hold on. Conflict of law rules.
Yeah.
It's like we're adding even more rules to an already complex situation.
It seems that way at first,
Yeah.
but it actually makes sense. Each state has its own set of rules
Okay.
for deciding which state's law should apply.
Okay.
In a multi-state dispute, think of it like each state having its own internal compass
Okay.
to help courts navigate these legal crossroads.
Okay, so let me see if I've got this straight. Let's say we have a case. In a federal court in Arizona,
Okay.
the case involves parties from both Arizona and California.
Right.
Now, if I understand correctly, the federal court in Arizona might have to apply California law.
You got it.
Okay.
It really highlights how committed federal courts are even after Erie
Right.
to respecting the nuances of state law systems. It's not just a matter of federal law always trumping state law.
It definitely adds a layer of complexity. Our
Yeah.
research indicates that beyond this multi-state dilemma,
Right.
Erie left a few other unanswered questions hanging as well, right?
Absolutely. Another big one was how federal courts should handle situations
Okay.
where they need to apply state law.
Right.
But the highest court in that state hasn't actually ruled on the specific issue at hand. It's like showing up for a play, but the lead actor is missing,
Oh, no.
and there's no understudy.
So how does a federal court proceed in those situations? Do they just make an educated guess?
It does involve a degree of educated guesswork,
Okay.
but there are some guideposts. The Supreme Court addressed this issue in cases like Gustin v. Sun Life Insurance and Commissioner v. Estate of Bosch. Essentially, federal courts have to put on their detective hats
Oh, wow.
and predict what the state's highest court would do if faced with the same issue.
I imagine that can lead to some interesting legal arguments on appeal.
You're absolutely right. This area of law requires a lot of careful analysis and interpretation,
Yeah.
which is what makes it both challenging and intellectually fascinating.
Speaking of challenging, there's another crucial question that Erie didn't fully answer.
That's that.
How to distinguish between substantive and procedural law.
Right.
This distinction feels fundamental to everything we've been discussing.
It's a critical distinction.
Mhm.
Remember, Erie established that state law governs substantive issues,
Right.
while federal law generally governs procedural ones in these types of cases.
Mhm.
But as you hinted, drawing that line in practice is often easier said than done.
Right, because if it's a substantive issue, state law takes precedence.
Right.
But if it's procedural, federal courts get to run the show
Right.
based on the federal rules of civil procedure. It's like having two sets of tools, but knowing which tool to use for which job isn't always clear.
Precisely. And in a legal system as complex as ours, it's no surprise that there has been a great deal of debate and case law trying to pin down those definitions. What exactly constitutes a substantive issue versus a procedural one can get very nuanced.
Okay, so we've got this constant tension between state and federal law.
Mm-hmm.
And now we're adding in the challenge of figuring out what's substantive and what's procedural.
Yes.
There must be some sort of method to the madness, right?
Thankfully, there is.
Okay, good.
This is the way the case of Guarantee Trust v. York enters the picture.
Huh?
It's a pivotal decision because it introduced a test
Okay.
to help navigate this very dilemma.
A test. That sounds intriguingly scientific for such a subjective area of law.
It's a very important tool in a judge's toolbox.
Right.
This particular test is called the outcome determinative test.
Okay.
And it basically says that if using federal law instead of state law would significantly change the outcome of a case, then state law should be applied.
So it's about ensuring fairness.
Exactly.
And avoiding situations where you get a different result just because your case happens to be in federal court.
Right.
I can see how that aligns with the spirit of Erie.
Exactly. It's all about preventing the kind of forum shopping
Right.
that was happening in the wake of Swift v. Tyson,
Right.
where people could try to game the system.
Right.
By choosing the court, that would be most sympathetic to their case.
The outcome determinative test, a valiant attempt to bring some order to this legal balancing act. But knowing how these things usually go,
Right.
I'm guessing it wasn't a perfect solution, right?
You know your legal history.
Right.
As with any good legal test,
Right.
there were some nuances, exceptions, and further refinements.
Sure.
To really understand how this substantive versus procedural battle played out, we need to look at Byrd v. Blue Ridge,
Okay.
a case that added another dimension to the debate.
A new dimension. This legal labyrinth just keeps getting more intriguing.
That's right. Byrd v. Blue Ridge added a fascinating wrinkle to this whole substantive versus procedural puzzle. To set the stage, this case revolved around whether a certain legal question should be decided by a judge or a jury.
Ah, the classic debate about who gets to make the final call. So which way did state law lean, and which way did federal law lean?
State law said the judge should handle it, while federal law pointed towards a jury trial. It presented a direct conflict between the two systems.
A real showdown. So in situations like this, how does that outcome determinative test we talked about earlier come into play? Did they determine that having a judge versus a jury would drastically change the outcome, and thus they defaulted to the state's preference?
It's not quite as simple as that Byrd introduced a new concept called the balancing test. Instead of just focusing on the outcome, the court said we need to weigh the interests of both the state and federal systems in these situations.
Okay, so it's a balancing act now. Sounds legally acrobatic. What kinds of interests are we trying to balance here?
On the state side, there's the interest in having its laws applied consistently within its borders. But on the federal side, we have important considerations, like the Seventh Amendment, which, as you might know, guarantees the right to a jury trial in certain civil cases.
So in Byrd, it was a question of whether the state's interest in having a judge decide this particular issue outweighed the federal right to a jury trial. Not an easy call.
It was a close one, for sure. In the end, the Supreme Court decided that in this specific instance, the federal interest in upholding the Seventh Amendment right to a jury trial held more weight.
So the takeaway here is that it's not always a clear-cut state law versus federal law battle. Sometimes it's about figuring out which system's interests are more critical in a particular case.
Exactly. It's a more nuanced approach than simply saying one side always trumps the other. And that brings us to another pivotal case in this legal saga. Hanna v. Plimmer decided, in 1965, Hanna introduced a two-part test to bring more clarity to this interplay between state and federal law, especially when it comes to those all-important federal rules of civil procedure.
Ah, those federal rules of civil procedure. We've touched on them a bit, but it would be helpful to understand them better. They essentially dictate how things run in federal court, right? They're like the rule book for the legal game, so to speak.
That's a good way to think about it. And the Hanna decision really solidified the power of those federal rules in federal court proceedings.
Okay, tell me more about this Hanna test. How does it work in practice?
It's actually pretty straightforward. First, the court asks, does a federal rule of civil procedure directly address the issue at hand? If the answer is yes, they move on to the second question. Is this federal rule valid under the Constitution?
And if the answer to both questions is yes, then what? Do federal rules essentially win out? Do they supersede state law in those instances?
In essence, yes. The Hanna decision reaffirmed that when it comes to procedural matters, those federal rules of civil procedure, as long as they're constitutionally sound, take precedence in federal court, even if they clash with state procedures.
So it's like having these two sets of tools, state law tools and federal law tools. And Hanna provided a clearer roadmap for when to use each set, especially when dealing with procedural matters in federal court. But, and you can tell me if I'm being overly optimistic here, I'm guessing even Hanna didn't completely eliminate the need for interpretation, did it?
You're right to be skeptical. As with many areas of law, there's still room for interpretation. Determining whether a federal rule is strictly procedural or if it starts to encroach on what some might consider substantive state law, can still lead to debate.
Right, because as we've seen, that line between substance and procedure can get blurry. Our sources point to Gasparini v. Center for Humanities as an interesting example of how these tensions can play out. What was the gist of Gasparini?
Gasparini is a great example of the court trying to strike a balance even when state and federal laws seem to be at odds. In this case, a jury awarded what the defendant considered an excessive sum of money in damages.
Ah, the age-old question of how much is too much when it comes to damages. So what happened next?
The defendant challenged the award, citing both state law and federal rules for guidance on how to handle these situations. It became a question of which standard should apply.
Okay, so we've got a potential too much money problem, and both state and federal law have something to say about it. What did the court decide?
They got a bit creative. They determined that the state law standard for evaluating excessive damages, which happens to be stricter than the federal standard, could be applied in this case.
Hold on, they allowed state law to influence a procedural matter in federal court. I thought Hannah gave federal rules the ultimate power in that arena.
It's not quite that black and white. While they allowed the state law standard on excessive damages to guide the initial assessment, they also preserved the federal court's ability to review the award to ensure it aligned with the Seventh Amendment.
Ah, I see. So it was a kind of compromise. They found a way to respect both the state's interest in regulating damages and the federal interest in ensuring fair trials.
Exactly. Gasparini shows us that it's not always an either scenario. Sometimes courts can find ways to harmonize seemingly conflicting state and federal principles.
Finding harmony in the legal system, I like it. Our time is quickly winding down, but we'd be remiss not to at least touch on Shady Grove v. Allstate, a 2010 case that added yet another layer to this ongoing debate. What new wrinkles did Shady Grove bring into the mix?
Shady Grove involved a class action lawsuit, and a state law came into play that appeared to limit the possibility of bringing that type of lawsuit. This raised the question of whether that state law could supersede the federal rules of civil procedure, specifically Rule 23, which governs class actions in federal court.
Ah, so it's back to the federal rule versus state law showdown this time, with Rule 23 entering the ring. How did this legal battle unfold?
Well, it was a split decision, which isn't uncommon for the Supreme Court, especially when dealing with complex issues like this. Ultimately, the court determined that Rule 23, as a federal rule of procedure, took precedence over the conflicting state law.
A win for federal procedural power in Shady Grove. But I'm willing to bet that this debate about where exactly the line is between a federal rule being truly procedural and when it might be stepping into substantive territory is far from over.
You're absolutely right. Shady Grove reinforced the idea that even with tools like the Hannah test and precedents like Gasparini, there's still plenty of room for interpretation and, at times, disagreement. This area of law is constantly evolving, with each case adding a new thread to this intricate legal tapestry.
It's been quite a journey unraveling this legal tapestry today. We've covered a lot of ground, from the early days of Swift v. Tyson to the complexities of Shady Grove. As we start to wrap things up, what would you say is the key takeaway for our listeners? What should they keep in mind as they navigate this legal labyrinth?
I think the biggest takeaway is to remember that the lines between state and federal law can get blurry, and courts are constantly working to find the right balance between the two. These cases often hinge on subtle distinctions, and understanding the history and evolution of the Erie Doctrine is essential for making sense of these complex legal battles.
It's about understanding the rules of the game, even as those rules continue to be shaped and refined. Any final thoughts for our listeners before we sign off?
The next time you come across a case that involves a conflict between state and federal law, think about the principles we've discussed today. Try to identify the key issues at play. Consider which system's interests are at stake, and see if you can predict how a court might try to find a balance. It's like flexing those legal muscles we've been working on today.
It's been an absolute pleasure diving into these fascinating legal waters with you today. And to our listeners, we hope you've enjoyed this deep dive into the fascinating world where state and federal laws collide. Until next time, keep those legal minds engaged, and remember, the law is more intriguing than you might think.